The tourism and hospitality sector in both Namibia and South Africa is facing a sustainability crisis. Their losses deepen due to insurance companies rejecting or delaying valid claims related to the COVID-19 pandemic. When it comes to larger claims in Namibia, several insurers are fighting hard to limit quantum and the indemnity period for which they are liable. This interview aims to help Namibian policyholders understand some of the key issues.
The BI claims, of course, being extremely rare events that we don't see as often, these black swan events that the COVID-19 caused, are currently in our courts regarding the liability of brokers rather than the insurers. To date, the South African judiciary has found in favor of the policyholders, and we have seen most of the companies paying out to the policyholders or either offering settlements that are quite acceptable to some of the policyholders. But at the moment, the cases that are pending are cases where the policyholders have decided to hold the broker who was supposed to procure the insurance liable to pay. The insurance companies are being held liable by their policyholders, and because it appears that some restrictions exist in some of the clauses and the policies regarding business interruption claims and the extent of which the policyholder is protected, the insurers being primarily the targets of litigation, of course, because the insurers are the primary contracting party. However, the brokers that facilitated the insurance, the brokers that promised cover to the policyholders, and the brokers that in fact had to do risk analyses of the policyholders' situations and failed to foresee COVID and the business interruptions it could cause, are now being targeted by the policyholders as a possible second course of recourse. If one does not succeed in claiming from your insurer, then trying to get at least something from the broker would be the last resort. And we have been expecting to see that for a while now, because not all policyholders succeed with their COVID-19 claims. Many of them, of course, restricted by the policy descriptions and the extent thereof. The cases were heard all the way to the Supreme Court of Appeal, and to date, the policyholders were always the successful parties in the litigation. So in South African law, the BI claims were found to be the cause caused by the virus that caused the lockdown. If I can just briefly explain two things. Firstly, the South African cases were all in a heard in a very short time period. And in this time, the courts were extremely favorable towards the policyholder. At this stage, there are about 2 of our big insurance companies who are still not willing to pay out. However, there is no appeal at the moment. I think the closure of the borders was obviously not because of anything other than pure evidence that COVID would come into the country and would in fact create a disaster. So the borders were locked because of COVID. So COVID is the trigger event for the losses. That is the simple explanation. The important part of this issue is causation. And causation is a general concept in most jurisdictions in the world. It means that the event must cause the loss or damage. There must be a physical chain of events. And then we also test causation in a legal sense, where we ask whether it was foreseeable that a specific conduct or a specific event would cause certain losses. And that is what served in the international courts and South African courts and in your Namibian courts. Of course, that is the primary point that we're working on. We ask, did a person have business interruption insurance? First question. Second question, did the wording of the clause enable him to bring the event that we had, the COVID pandemic, within the four corners of the policy? And then we ask, did the event, being the COVID, cause the loss? And the big dispute is what happened between COVID and loss is government lockdown in the middle. So we have a chain of events that is literally interrupted by government intervention in the middle. However, our courts could maneuver around that to say that COVID caused the government lockdown, which caused the loss. So in other words, the COVID required by necessity government intervention, and that caused loss. Therefore, it is a continuous event, the virus and the government intervention. The two are inextricably linked to each other, and they then cause the loss. And that is why the COVID equals the result of loss, although we have the government in the middle. If you think the virus away, would the lockdown still have happened? No. If you think the lockdown away, would the virus still have been there? Yes. And that is why the virus remains, together with lockdown, the cause of the loss. So that is in essence what the fight is about. And the insurers lost in most countries. So I deem it extremely favorable that a group of insureds have taken it to the Namibian courts. A legal precedent has definitely been set in South Africa. And I must just mention this, that until the 90s, Namibian judgments were also reported in South African law reports. And our laws are very similar. And therefore, I think that the precedent that has been created in our courts and the law that has been applied and the way in which it is applied to the COVID scenarios will apply in the Namibian courts in the same manner. I do not see the evaluation of causation and the interpretation of the clauses being extremely different. They are similar to South African law. The development has not been to deviate extremely far in these cases. We follow them because the English law is primarily the source of insurance law, and what happens in England directly reflects on the approaches that our courts might take in insurance cases. The insurance market, you must remember, is basically an international market. Insurance can be seen as supranational in the sense that most countries have similar laws or apply the similar basics of insurance law. It is then specialized in smaller pieces of legislation. For example, the elements of an insurance contract, the way in which we interpret insurance contracts are all very similar across the board. How we test for causation, that is all very similar. There are then statutory deviations regarding medical schemes, for example. That's a form of insurance that's highly specialized and regulated by legislation. So most countries have the same basics. And the English law and the London market, being the home of Lloyd's of London as well, is generally seen as the center point of universal insurance law. And the country's courts are very highly authoritative in the way in which they deal with insurance matters for other countries, common law countries, from which we all received our insurance law provisions. Okay, we all have grown from the so-called lex mercatoria, the old mercantile law, into our various systems. So we all have commonalities. We all have the same general principles. And that is why the English courts are extremely important for insurance law as well. Let's first just quickly clarify how reinsurance works. Reinsurance is also insurance. This is where the primary or direct insurer who provides insurance to the policyholders, where that direct insurer takes out insurance for its obligations with a reinsurer. So it's an extra level of insurance. We have the basic policyholder and primary insurer at the bottom. We also call him the direct insurer. And then he takes out insurance with a reinsurance company. It is also possible for a reinsurance company to take out an extra level of insurance, and that we call retrocession. So it is possible for an insurance company to insure its liabilities towards its policyholders with a larger reinsurance company. And this is done by ways of business. This is standard practice. Now, reinsurance, although it is insurance law, it still has some extra special principles that apply to it. But it is there for the protection of the direct insurer. Some insurers do not take out reinsurance for all of their risks, and some do. Some only partially reinsure their risks. Of course, it's open to them how they want to protect themselves. But now what has happened is that reinsurance cover for business interruption claims is being challenged due to the length of the pandemic happening and the time periods. Usually one takes reinsurance for very specific events, but there are things in reinsurance policies such as hours clauses. And an hours clause will say that the reinsured event is only covered for a period of 168 hours of length. And also other clauses could possibly create a problem that one must give notice within 30 days from the date of the event. And then the reinsurance kicks in. Now with COVID, the question is, how long did the COVID event last? Well, as we know, it's nearly 2 years now. And in this case, the reinsurance is way too limited. It is really woefully inadequate. Also, the notices that were given by insurance companies to their reinsurers, when did that time period start running? Did it start with the first infection in Wuhan, or did it start with the first positive case in the country, or did it start with the first claim that was made to the insurer by one of the policyholders? So that is the relationship between the insurer and the reinsurer, okay? The direct insurer and the reinsurer. Very few companies had sufficient reinsurance, but that is not the problem of the policyholder. The policyholder has a contract with the insurer, the direct insurer. This does not mean the policyholder has a contract with that insurer's reinsurer. That's not a possibility. So the policyholder is purely bound to its own insurer, the direct insurer. The only way in which a direct insurer could deny liability. So the only way in which a direct insurer could say to a policyholder, I can't pay you because my reinsurer did not pay me, is where that was expressly stipulated in the insurance contract. So only in those contracts where a direct insurer agreed with a policyholder that the direct insurer must only pay the policyholder once he has received the monies from his reinsurer. Only then can an insurance company use that excuse not to pay a policyholder. Your duty to pay your policyholder is not dependent on whether you get your money from your reinsurer. That is not an automatic provision. Only there where you have written it into that policy can you rely on that. So any broker or any company that says to Benny in Usakos, we can't pay you because our reinsurer did not pay out, therefore we don't owe you anything. That is blatantly incorrect. That will only be where the policy was conditional upon the receipt from the reinsurance fund or claim. That is very, very clear in law. Now, what the reinsurers also agree to is so-called follow the fortunes, follow the settlements clauses. And that is that the reinsurer will only pay after the fact, and he will pay out what the direct insurer managed to save, the claim that was still paid out after savings. So anything that follows the fortunes or follows settlements made by the direct insurer, that the reinsurer will pay. But it is no excuse to just across the board deny liability for payment because the reinsurance was either inadequate or is not willing to pay out yet. That is not automatically the policyholder's problem. I think the whole situation caught everybody off guard. It is not totally unexpected that something like this would happen. However, I think the authorities were not geared up to very quickly take firm stances in a position like this. Under a very short time period, these various conduct authorities or financial supervisory authorities had to take extremely big decisions and had to manage the positions. Now, the Financial Conduct Authority in South Africa did very well. They issued clarifications, they issued directives, and they issued some of their stances. They call it a stance, which is basically an opinion, but it is backed up by the authority. So the South African Financial Services Conduct Authority issued a few very valuable directives. The first, that property loss is not covered under BI, business interruption insurance. So they clarified the issue on property damage or property loss, which the virus obviously does not cause. That is excluded. And then they issued another directive, which I have not seen in your law. It might have been given by your conduct authority, but that was that our insurers must consider intermediate relief. In other words, that our insurers pay some form of intermediate payments in order to tide over the businesses that are under severe stress, pending a future resolution of the disputes, of course. But our FSCA went one step further, and they said any interim relief that is paid out may be kept by the policyholder, irrespective of the final outcome of the case, of the dispute between the parties. So that was of great value. Not all insurers started paying, but some did, and that assisted. And then the final stances that were issued dealt with causation, and also something you just mentioned, and that is where the event took place, the kilometers of infection or positive diagnoses, where the kilometers played a role. And our FSCA said that if you are covered for notifiable diseases or infectious diseases, and it must be within a certain radius from your business address or your residential address, that only proving one positive case in that area would be sufficient. You do not have to provide the identity of the patient, the age, where the patient is, but only a positive diagnosis would be sufficient to tick that box of notifiable disease within a very specific area. Another thing that hit our courts initially was that a notifiable disease had to be classified as notifiable by a local government or a local authority. But in the COVID case, it was the government, the state itself, in other words, the national government, that actually classified it as an epidemic and recognized it as a pandemic. And there were some disputes from the insurers that this was not a proper identification or classification of a notifiable disease, which luckily common sense prevailed. And the court said, whether the government is local or whether it is national, it's still an emergency, it's still an epidemic, and it's a declared notifiable disease. You see that, of course, insurance companies must remain solvent. That is of great concern, that they would go insolvent because of the massive load of business interruption claims. However, it was a first knee-jerk reaction that there would be massive insolvencies and liquidations of these firms or the companies, the insurance companies. It appears that many of the insurance companies have survived this rather well. The BI clauses, also in some questions that you directed to me via our email, are not always perpetual, and they are not unlimited. So very few insurers had to pay out business interruption claims that would last, for example, for 2 years and be of such great extent that they would literally close down the larger firms. Now, insurance depends on the fund, and members, by definition, cross-subsidize each other for covers of risk. So the premiums all go into the big pot, and everybody has an opportunity, providing that an event and a loss that they suffer falls within the parameters of the agreements, have a right to share in that specific pot of funding. So yes, it is the case that the bigger fund reserves now have to subsidize or pay the business interruption losses. However, that is the way in which the world works. If, for example, there is a sudden meteorite strike, then the victims of that deserve to be compensated from the fund, provided it is insured. So yes, the insurance companies are taking strain. However, a lot of them have reached agreements with their policyholders to pay the amounts to the policyholders over a longer time period, which then offers some form of temporary relief to the insurers, that they could postpone all of the responsibilities to pay over a longer period of time. And that, of course, is something that insurers should consider doing, helping out the policyholder and paying certain amounts over a time period. Well, if you think when COVID struck South Africa now, it was March, went into our big lockdown, 28 March 2020. And the litigation commenced against the insurance companies, big panic, solvency, etc. When it came to December 2020, the bonuses that were still paid out were a clear indication that the companies were not in such financial constraints as initially one thought they would be. So it has not been the biggest disaster for the solvency of insurance companies that was predicted. Not all BI claims have been paid out. Of course, there are still a lot of claims outstanding or pending. Yes, it is in their discretion unless there is some form of supervisory or regulatory provision or system that requires the funding to be classified in certain categories and to be used up to certain limits. That will depend entirely on the type of insurance, the type of company. But as far as business interruption insurance is concerned, all of that falls in the big pot of basic cover that people have. You have house insurance and you have car insurance. And then if you run your own small business, you also have business interruption insurance. So there's no reason why the house insurance portion should not cross-subsidize the business interruption portion. So it is a question of the law of the country regulating the specific insurer, and then of course the policy provisions being of extreme importance. They are separate entities. I always talk to my students about the Gupta structure. You know, you've got the holding company, and then you've got the subsidiary, and you've got another subsidiary, and you've got another subsidiary. And each of these are separate entities, and they are not required to bail each other out. However, one would think that a larger company group would attempt its best at saving or salvaging one of the subsidiaries rather than let them go down the tubes and pay out huge bonuses on holding company executives. I just found it extremely strange that if Hollard loses in South Africa, that they are still willing on the same facts, on the same policy wordings, to resist claims and to actually get involved in litigation. That was strange to me, because I think if one of your subsidiaries has gone through the wheels, the others will also follow the same route. So opposing claims was for me a surprising move. I think irresponsible in a way, because of all the judgments in all of the countries that have gone against insurers to still perpetuate litigation on the same scenarios, for me is not best practice. If I have a policy that is for a year, however, there is a 3-month period for BI, what do I enjoy coverage for? The full year that the policy's entire validity is for, or only the 3 months for the business interruption or BI? And it is the latter one. The BI is usually also limited in time in the primary insurance policy, that one can only claim for a very short time period of losses, which sadly COVID has very often exceeded. What we saw immediately, of course, were changes of cover that insurers would midterm, by notification of 30 days in, for example, a policy that would last 5 years, by 30-day notification withdraw business interruption cover. Now that's where our Financial Services Conduct Authority stepped in and specifically stated that no insurer may change these benefits during the existence of the policy without consulting with the FSCA. And that meant that there had to be consultation, there had to be, I suppose, indications of budgetary issues and of the fallout on policyholders. So that was very quickly in South Africa limited, and the insurers did not pursue that line very aggressively. So what we have with a fine print, and nobody reads their whole policies. I mean, present company included. You have your document, you're happy, and there you go on with your life. And only once you suffer a loss and there is a rejection of your claim by your insurance company, do you actually investigate the policy document that applies to your situation. I have gone through thousands of policies, and that is not an exaggeration, and providing opinions on policies for attorneys for a very long time, reading through the policies, and actually shocked at the poor quality of the policy documentation in the first instance. And the second one is the realization that the average consumer does not understand the documentation presented because it's convoluted. One will have a schedule of insurance that's at the front of your policy that gives you a very brief description of the class of insurance that you have taken out: motor vehicle insurance, home contents insurance, BI, fire, and then the premiums are stated there. But that is then supported by an extensive range of documentation and terms and conditions. And in those specialized terms and conditions, you will find the extensions, where the cover extends to certain things or certain events, and then, of course, the limitations and exclusions. And it is in those fine print terms and conditions that we mostly found the fact that BI is excluded entirely or limited in some or other way. I have seen some highly disturbing policies on which I hope the policyholders will take further action. The first thing is not to lose faith, because international judgments and South African judgments are in favor of the policyholder on the main turning point issues. The second point is form groups, join resources, and follow the procedures by approaching the financial service supervisory bodies, boards, councils, and approaching the courts then as a group, not a class action, not necessarily a designated class action. That takes a long time. But as groups of associations, for example, coming together. I saw the interview held with one of the Swan people, and it drove me to tears. It was very emotional to see that absolute desperation of the tourism industry on that level. And I would really recommend pressure by groups and societies on these specific insurers, that one has the ability to try and get an interim payment being made, the way in which it was made in South Africa. And then pursuing this because there is merit where the policy provides for the BI. The lack of reinsurance is no excuse unless you find that in a policy, which is very far and few and far between. Pursue it. Do not give up, because your insurance is there for these events, for things that happen that you cannot work with or on your own or suffer on your own. So for me, that is the most important, is get together, stand together, and make sure that you have resources to reach the goal of managing the claims that are due. It depends on the policy time, of course. You know, if you have to give notice of the claim within a certain time period, and you haven't done so yet, and you've been in lockdown for a year, for example, then of course that could be a problem. We grappled with that as well. The policies all state that if you have suffered a loss, you must notify your insurer within certain days or weeks of this loss and your intent to submit a claim to the insurer. And our question was, do you really think it is necessary for the individual insured policyholder to have to tell his insurer, there is COVID, there is lockdown, I am suffering a loss? So that I haven't seen insurance companies being tough on. They haven't said you haven't given us sufficient notification that there's a viral infection, because it's universal knowledge and it's objectively determinable that it is present. The exact events of government lockdown are certain, the dates are there. So I think one should move as quickly as possible, and not sit and wait for the outcomes of cases that are already possibly taking place in Namibia, but to form groups of similar consumers, of similar complaints, and to also direct your complaints to your, as I said, regulators, and possibly then consider additional legal action to enforce the ones that are already in your court process. Why nobody has spoken of the United States is because they have a different system. The US has a super fund. It's called the super fund. They work on a fund-based system. It's the Comprehensive Environmental Compensation and Liability Act that pays out for environmental disasters. And that fund is something that one could really consider for these natural events. Remember that COVID remains a natural event. Many of the insurers were rather tense on getting some form of factual evidence that this was not a man-made virus from Wuhan, because if it was man-made, it's not a natural event. And if it's not a natural event, they don't have to pay out. If it is a natural event, then of course it falls within the parameters of the cover clauses. So I think really the pool insurance is another possibility, where insurers now decide to pool their resources. And now we're not talking holding companies, subsidiary companies. We're talking of completely independent insurers pooling resources in order to weather this storm until it has stabilized. I know that has been a very strong drive in European countries to pool resources of the insurance companies involved. And I don't think that has been addressed in our part of the world. Exactly, yes, exactly, the stokvel. And that's, you know, that's why we have to just remember insurance has the same origin. In every country, it has the same origin, and it comes from this basic stokvel idea. It's all put money in, and the day that something goes wrong with one of us, you get it out. Or every second month, somebody gets a payout. And if there is a disaster, the whole stokvel fund will pay. The policies that are investigated usually give you quite extensive formulas for calculating the loss, how you calculate your lost profits, wages of staff, you know, the way in which your tax implications could also affect your specific claims. So I have seen business interruption documents in the policies that are quite clear on what the insurer wants to see in order to pay out business interruption cover, and the insureds must make sure they comply with that to the letter. Provide proper statements with dates, with proof, everything, that your claim that goes in is as best formulated as you can formulate it at that time, and supported by the evidence that is required. The 40-kilometer radius, proof there's a hospital, a clinic, a doctor who diagnosed someone, very important. And then, of course, your calculations of the amount of money that you actually lost due to this COVID pandemic. And finally, always considering there will be time limits. No, that is the exception. Guests, being guests coming usually from overseas, it would be a very limited cover if the cover was only for national guests. You know, if I think of our own country, our tourism industry is supported not as much by our national people from Gauteng traveling to Western Cape, as much as it is from international guests, and especially Namibia as well. So it's very concerning to hear that foreign guests are excluded, or the income they bring in is excluded, because these are the majority of the guests. Well, again, I'm coming back to the sharing part, because as soon as you make contact with others who are in the same position you are in, it provides an emotional support that you are not alone. And the reaching out of people towards each other, obviously we know on a smaller scale, neighbors helping with shopping, older people in lockdown, not being able to travel, etc., etc. But in the bigger industries, we've found that sharing the sorrow is something that already assists, and you can do so by joining together. And in the process of trying to create a new beginning by getting as much as possible responsibly claiming under insurance where you have a claim, obviously, create some form of community, sense of community, which we all basically have to get back. We lost it over a few decades or centuries, I might say. Yes, you see, we call it a black swan event because it is such a rare event that was not planned. We see ever so often something that happens that was never expected. It's very much the Titanic, you know, she will never sink. And then we continue with our lives as they are, and something happens on a Tuesday afternoon that nobody could have foreseen. One of the examples, the first ones were tsunamis that were suddenly being caused wider than they were always caused around Japan and the eastern areas. The prevalence of tsunamis in certain limited areas was, of course, well known, well documented. But suddenly the intensity became so much that it caused damage and went wider. It circled out into countries that had never experienced it. So 2004, we speak about the Phuket tsunami, when we had that massive destruction caused by that tsunami, was quite unexpected, and a lot of travel insurance was not prepared for the fallout of that. Another example was that little volcano in Iceberg, you know, the unpronounceable name of it. I'm not even going to attempt to pronounce it. Interestingly enough, many of the national air carriers in the UK did not have cover for volcanic ash or volcanic eruptions for national flights. For international flights, one would have that because you fly over Fiji and Hawaii and other areas where there might be volcanic activity, but you do not expect that in Wales and Scotland. And therefore, it was quite a surprise when the air traffic came to a complete standstill because of volcanic ash. And that brings us to this next question, I think, that you would ask, or that I think we should discuss, and that is the possibility of describing risks so broadly that it basically catches any event that could potentially now happen. Could we have foreseen COVID? That's the question. Could we have foreseen it? And the answer is, well, yes, because of many viruses the past 2 decades, 2 to 3 decades, that have gone rogue. If we think about Ebola, and we have SARS, and we have MERS, it is not a complete surprise that at some stage there could be a microorganism causing some form of loss. For the insurers who mentioned SARS and MERS in their policies, I think there was absolutely no escape. They couldn't say, yes, but we didn't know about COVID, because they already considered a viral epidemic by ways of referring specifically to SARS and to MERS. Notifiable disease is a very broad term. And, you know, under that, you can find quite a lot of scenarios that people might not mention specifically individually by name, but it catches up quite a lot of natural occurrences or events. We are heading into uncharted territory with climate change. Climate change is going to present risks that not all risk managers are able to predict. We are going to see fallout in ways that we cannot imagine. Already, the intensity of storms has changed and increased. If we just touch back on the reinsurance that we discussed, these hours clauses of damage caused within very specific hours that are covered by reinsurance are aimed specifically at storm and those natural occurrences, landslides, etc., flooding, earthquakes, because of a very limited time that those events usually cause damage for. The cyclones and the hurricanes and the twisters and whatever you might find on the eastern seaboard of the US. But COVID was not limited in time. It was not a temporal event, and that challenged the wording that we have in our policies.
If you have a story to tell, contact strings@netactive.co.za.